All right. Good afternoon. My name is Zane Johnson, and welcome to today's webinar on leveraging your intellectual property. So I actually gave this webinar a week ago, and then I realized when I went to send it out this past Friday that I hadn't actually pressed the record button. So I'm going back and I'm re-recording it to make sure that y'all have access to a recording of the actual presentation. So going to be running back through it again. There's no one else who is watching live, but hopefully the recording is going to be helpful to all of you after it goes out. So I always start, and I feel like what would any legal workshop or webinar be without a disclaimer? And so I want to start just by saying that all of the information that I provide today is just that, information. So at the end of the day, hopefully it helps to answer some of your questions, provide you with some clarity on how you can move forward, protect your intellectual property, and leverage your intellectual property. But at the end of the day, there are going to be some questions that you might walk away with. There's going to be some information, some things that I say that it's new to you, that you haven't heard of before. And so if you have any questions or if you're looking for further clarity, definitely want to encourage you to sit down with someone one-on-one to get actual advice. Talk with someone who can actually get a chance to ask you some questions, figure out your goals, figure out your circumstances, figure out the specifics of where you're trying to get with your business, and then can provide you with actual advice on how you want to move forward, right? Again, I appreciate everyone for joining, for watching this recording, and we'll just go ahead and jump right into it without any further ado. So before we get to the legal aspect of things, I just want to start by introducing myself. My name is Zane Johnson. I am the founder and managing attorney of MZA Legal. MZA Legal is a Black-owned virtual law firm that focuses on helping self-funded entrepreneurs build a solid foundation for the future growth of their business. So I help entrepreneurs with everything from setting up LLCs to drafting and reviewing contracts to helping them to register trademarks and understand what their intellectual property is and everything in between, right? So a lot of what I like to call business legal strategy, really just making sure that you are on a solid foundation so that you can build your business to become the dream business that you want it to be, escape the rat race, have that financial freedom, and ultimately create generational wealth, and live in your purpose, whatever that looks like, right? And so what I often say to folks is I'm the person there who, when opportunity comes knocking, I'm there to hand you your pants so that you can be ready to answer the door, right? Again, appreciate everyone for joining. And if I can ever be a resource, I am. You can search me again. My name is Zane Johnson, MZA Legal. You can find me. I'm not hard to find. Definitely feel free to reach out if I can ever be of service. So I actually want to start with a little exercise, perhaps, right? And maybe just close your eyes and imagine, right? So imagine it's December. No, let's say it's January, right? So it's after the holidays. Everyone is sick of winter by this point. But rather than being in the cold, shoveling your car out of the snow or whatever the case may be, warming your car up in the morning, you're actually sitting on a nice white sand beach. It's 85 degrees. A nice cool breeze is blowing through the trees, and you've got a cold drink, and you're sitting next to your spouse or your boo thing or whoever it might be. And you got your cool drink, and you get a notification on your phone. You look down and you see that it's your bank, it's your banking app, and you notice that another check was just deposited into your bank account, right? So you're really, and you're living the dream, right? So open your eyes. And so the reason I wanted to start with this little exercise of like imagining the good life is because I think at the end of the day, right, regardless of what your business does or kind of what you're interested in doing, we all want to be able to live the type of life that we want to live. We all want to achieve the goals that we have set out for ourselves, live our dreams. That's part of what creating and starting a business is all about. And so whether that dream for you looks like sitting on a beach and being able to sip a cool drink, or whether it looks like, being directly in the community and doing work in the community, whatever that dream looks like for you once your business is fully built, intellectual property is a key aspect to allowing you to do that, to giving you the freedom to be able to spend your time how you like, whatever that might look like for you, right? So how can we, at the end of the day, make money while we sleep, create generational wealth, and free ourselves from the rat race all at the same time? Assets, right? And if you're not familiar, if you haven't read like Rich Dad Poor Dad, or any other similar type of book where it kind of just breaks down like kind of different financial concepts, assets at the end of the day are property that you can use to generate income, right? So why would we start with this? Why, what does this have to do with intellectual property? Well, the reason is that as a business owner, as an entrepreneur, if your business does not own real estate, then the most valuable asset for your business is most likely your business's intellectual property, right? And so that's why it's so important when we talk about the value of intellectual property, the potential value of intellectual property, why it's so important to protect it, and ultimately why you want to think about and strategize around how you can leverage it to create more income for your business, is that at the end of the day, intellectual property is a way for you to create passive income for your business, to grow your business, and to free yourself in terms of being able to live the life that you want to live, right? So with intellectual property, and I want to give one example, because there's one example to me that really like illuminates this, really shows what I mean by how important intellectual property can be, or the role that it can play for you as a business owner to being able to create passive income, right? So my son, he's 2.5. He's got all his teeth now, finally. But he's got, training toothpaste that we use to brush his teeth. And on his training toothpaste are characters from the TV show Paw Patrol. And so if you're not familiar, Paw Patrol is a Nickelodeon show that features these, like, it's like 7 or 8 helpful puppies that kind of like go around and save the day every episode, right? My son loves the show. And it's part of the reason why we have this training toothpaste, because it has the Paw Patrol characters on it. He picked it out at the store, so on and so forth, right? And when you think about it, the interesting part from an intellectual property standpoint is that Nickelodeon is getting paid for the sale of toothpaste. But Nickelodeon is not a toothpaste manufacturer. They don't formulate recipes for toothpaste. They don't manufacture toothpaste. They don't distribute toothpaste. They don't sell or market toothpaste, right? But Nickelodeon still gets paid for the sale of toothpaste, same as they get paid for the sale of lunchboxes and backpacks and t-shirts. And these are all things that Nickelodeon does not make, right? And so at the end of the day, that's the true value of your intellectual property. And it's that ability, right, to create passive income through the things that you've created and been able to, things that you've created that have value to them, right? So that's what we're going to get into as we move through the next few slides, right? So starting just at the beginning of it all, what is intellectual property? Well, intellectual property is intangible property, right? That means you can't physically hold it necessarily, but it's intangible property that is the product of one's own ingenuity, and over which the person who created it may establish ownership, right? And so this is the best sort of like clear definition that we can give of intellectual property. But hopefully the examples that we give as we move forward to the examples that we see will kind of help illuminate what intellectual property is, right? So when we look at some of these examples, it really is across the board, right? It's t-shirt designs, drawings, paintings, different types of artwork, software code. You've got videos, photographs, business names, fonts, colors, websites, characters, scripts, customer data, customer lists, inventions, sounds, recipes, logos, books. I think I got everything on here and more, right? So there are so many different examples of what intellectual property is, or what can be considered intellectual property. But again, at the end of the day, it's something intangible that you've created on your own, and because you've created it, it's original. It falls into a category where you're able to establish ownership over it, right? So again, what makes intellectual property so valuable? Well, I talked about the ability to leverage your intellectual property and create passive income from it. And that really stems from the fact that when you create something, when you create a piece of intellectual property or IP, you have the right to exclude others from using it, right? So when you create something, it's your intellectual property. You have the sole right to use that piece of intellectual property, and therefore you have the right to exclude others from using it, right? Which gives you, one, a competitive advantage over your, competitors out there who don't have that intellectual property. But two, it gives you the ability to license your intellectual property to folks who would be competitors, or maybe they're not even competitors. Maybe you just created an invention and you don't have any factories, so you're going to license that invention to a company that has factories and has a supply chain and can, market and sell that product, right? So you can license that intellectual property. You can give someone the right to use it and to sell it. And ultimately, they pay you, whether it's in royalties or some sort of upfront fee or some sort of mix of the two. They pay you to use your intellectual property. So really quick on licensing your intellectual property, right? Because I kind of want to really get this, emphasize this point that we often think about intellectual property in terms of how do we protect our intellectual property, but that's only one side of the coin, right? The other side of that coin is how do we actually leverage it, right? And how do we actually make money off of our intellectual property to grow our business? How do we get the most out of it? And licensing your intellectual property is going to be the big way that businesses are able to do that, right? So you're going to license your intellectual property through a contract or through an agreement. And some of the key considerations that you want to think about here, and again, so I'm not going to go through everything. So when it comes to contracts in general, a couple of weeks ago, I did a workshop with Philly VIP on contracts. If you want to learn more on contracts, what goes into a good contract, I would definitely recommend checking that out. But the key considerations that you want to think about when it comes to a licensing agreement for your intellectual property are going to be the length of the agreement, right? So how long will they have this license to use your intellectual property? Because that determines at what point you can come back and renegotiate, right? Which is very important. Second, are there any limitations on their ability to use that intellectual property, right? So if it's Paw Patrol, for example, and I'm licensing it to a t-shirt company, am I only giving them license to use it on t-shirts? Or am I also giving them license to use it on shorts or shoes or backpacks or anything, right? Is that license exclusive or is it non-exclusive, right? Exclusive meaning they're the only one who will have that license, right? And if it's for a t-shirt, they're the only ones who are going to have a license to use it on t-shirts. If it's not exclusive, that means I can give them the license and I can give it to another t-shirt company and another t-shirt company, right? And that'll ultimately change the value in terms of what it's going to be worth to that company and what they're going to be willing to give me in exchange for that license, right? And there are other ways to sort of limit the license that you give to someone when they're using your intellectual property. But the third main consideration is going to be, what are you receiving in return, right? So I kind of mentioned this on the last slide. Is it an upfront fee? Is it a royalty? Is it a fee and a royalty? And what are those fees and royalties based off of, right? What does that kind of look like in terms of making sure that you are getting your fair share from what you created, while also recognizing that the party on the other side is going to be potentially doing a lot of the legwork, right, to create some of that income, depending on the type of intellectual property that we're talking about, right, and what the situation is. So if you want to license your intellectual property, I think one thing that is very important to point out is that you need to know or understand what it's worth. And I point this out because a lot of times when it comes to intellectual property and figuring out how to leverage it, the most difficult part is kind of scratching the surface on really understanding, like, what is this intellectual property worth? And what can I get for it? Am I making a good deal when I license my intellectual property to someone, especially if it's going to be exclusively licensed to someone? A good example of this, real life example, is when Marvel actually licensed for the first time Spider-Man to Sony, right? So when and I heard about this on a podcast, but when Marvel was purchased, and before it became Marvel Studios, they were really just focused on selling toys, right? And so they licensed Spider-Man to Sony, thinking Sony's going to make a movie, it's going to help us sell toys, and that's the real focus in terms of where we want to make money as Marvel, right? Well, Sony, took that license and made a Spider-Man film, and it blew up, right? No one expected. I think it was like the highest grossing movie of all time. And no one expected that, right? So, they made a second movie and a third movie. And Marvel was looking at it like, these movies are making a ton of money. We didn't expect these movies to make this much money. And now we're looking at the deal that we got in terms of licensing Spider-Man to Sony. And it looks like we got the short end of the stick here, because Sony's making a ton of money and we're not touching a lot of that, right? And that ultimately was part of the reason why, Marvel went out and created Marvel Studios, to be able to capture more of that income, right? So again, knowing what your IP is worth will help ensure that you get a good deal. And doing that, and in terms of figuring that out, there are kind of two folks that I think it's really important to have on your team. One is a financial professional, whether that's a CPA or, whomever, a financial professional who can really help you with sort of valuing and kind of thinking through, like, what does it look like, or what are the factors that go into valuing this intellectual property. And then the second is going to be an expert within your industry, right? And so that might be you, but someone who kind of knows, what is this typically worth within our industry, and who are the likely buyers? Like, what does the market look like for this piece of intellectual property, right? So I just want to throw that out there in terms of, when you go to license your intellectual property, it's really important to understand what it's worth, and what it's going to be worth to your potential what it's going to be worth to your potential buyers or customers for that intellectual property. So, like I said, the other side of the coin, right? On one side, you have leveraging your intellectual property, but the first piece to that, before you get to leveraging your intellectual property, you've got to protect it first. You've got to make sure that it's under lock and key, and that you have full control, that you're exercising full control over your intellectual property, because that is what's going to really lock in that value, right? As I said before, that right to exclude others from using your intellectual property is what gives it that value, right? What allows you to license it. And so I want to run through the different types of intellectual property and how you can go about protecting them. So there are four main types of intellectual property. There are trademarks, copyrights, patents, and trade secrets. All right. So a trademark, I think that this is one that people are typically most familiar with in terms of what is a trademark, seeing a trademark, understanding what trademarks are. But for those of you who aren't as familiar, or who aren't quite sure, And even for those of you who think you know, but maybe you have some misconceptions about what a trademark is, a trademark is really anything. It could be a word, an image, a symbol, a slogan, even a texture or a color, a sound, anything that is used to distinguish the source of a product or service in commerce, right? So out in the marketplace. And so we see trademarks all the time. It's something that we're familiar with, right? So what are some examples? Well, you've got Nike, right? The Nike swoosh. Everyone is familiar with that, and the brand, the goodwill that Nike has built into that, right, is where the value comes from, right? When people choose athletic clothing, a lot of times and I think I'm wearing Nike right now, a lot of times they're likely to choose Nike because it says something about who they are, right? In terms of, like, you think about Nike commercials, it's about winners and a culture of achievement and success, and being a hard worker, and it says different things, right? UPS, right? What can Brown do for you, right? When you see a big UPS truck, you think of a reliable service for sending mail, for sending packages, things that when you really need it to get there, you think of UPS, you think of FedEx, right? And so UPS, the color brown, is a trademarked example there. And then the last one, and I'm going to put the mic up to my computer speakers, so hopefully you can hear the sound, and it'll be something that's familiar, but we're gonna try this. So when I did that last week, no one could hear it. And so hopefully you heard that, but that sound, right? If you heard it, I'm sure it's familiar. It's the sound of a Windows computer shutting down, right? And so, that, again, you hear that sound, you're familiar, right? And so these are the brand aspects, or the assets, rather, brand assets, whether it's a logo, whether it's a slogan, a color, a sound. These are all things that serve to distinguish. They tell us, who is responsible, who put this service or product together, right? And so, um, it's important, right, to protect all of these, brand assets, because at the end of the day, they allow us to build goodwill. They allow us to establish that brand association, and then allow us to then leverage that brand association when partnering with other brands and other companies, right? So how do you protect a trademark search? Well, sorry, how do you protect a trademark? It actually starts with a trademark search. So I was getting a little ahead of myself, but protecting a trademark starts with running a search. All right. And running a trademark search, you can do that either by going to the USPTO website, and going to the TESS, the Trademark Electronic Search System, and you can search manually. But actually, my favorite way to search is to use software, right? So when I'm helping a client with a search and evaluation, I use a software called Markify. It is great. It's relatively inexpensive. You can run your trademark search and it will pop back. It will be a lot more thorough than you could be as an individual, because it's using all types of software and whatever the case may be. But it pops back all the results through the USPTO system and database, showing me things that are similar and that might create a risk for my trademark, right? Because at the end of the day, what we want to avoid is having a trademark that is likely to create confusion or that looks similar to someone else's trademark, right? If we have a trademark that looks similar to something that's already registered, we might not be able to register our own trademark, due to the likelihood that having those same trademarks registered using similar products or services would cause a likelihood of confusion. And so if you file an application and they say, hey, there's already a trademark here that's registered, that looks too similar to yours, or that sounds too similar to yours, or whatever the case may be, and it's a similar product or service, they might reject your application, because of a likelihood of confusion among consumers, right? With a trademark, you can apply for trademark protection with the USPTO. I got a few details here on that process. But your trademark, in order to be registered, your trademark has to be distinctive. Again, this kind of goes back to the purpose of a trademark is to help to distinguish the source of a product or service, right? So if your trademark is looks the same as someone else's, it's not serving that purpose. And it could be could face a barrier to being registered. Also, if your trademark is merely descriptive or generic, it might not be eligible for registration, right? So if I run a plumbing business and I might name my plumbing business the Plumbers, that's just something generic, right? It just says what it is that I do or what service I provide. So that's not something that's going to be eligible for trademark protection. Whereas if I name it Pinnacle Plumbing, that is distinctive, right? There's no clear connection between Pinnacle and plumbing. However, the key is going to be, is there something else out there that looks similar, that might prevent me from being able to register my trademark? Next, we have copyrights, and copyrights protect creative works of authorship, right? So think books, plays, movies, music, photos, designs, even software code. These are going to be creative works that are going to be shared or sold out in the public, right? And so having that copyright protection gives the creator the sole right to perform, protect, print, publish, and create new works from that copyrighted material. When it comes to copyrights, it is important to understand that there are some carve outs to that protection, right? So when I create something, I have rights to it just by virtue of creating it. And when I copyright it, which we'll talk about on the next slide, kind of what that looks like. When I copyright it, I lock in and I have even greater protection over those creative works. However, there's still something called fair use, and fair use allows for certain uses of copyrighted material without the owner's permission, right? So that might be for criticism or for comment or for news reporting, could be scholarship or research. There are a few different carve outs for fair use, but it's important to understand kind of on both sides what falls under fair use and what doesn't, whether it is that you're trying to use some material that someone else has created for your own business, or whether you've created something and you're trying to stop someone from using it. So how do you protect your copyright? So as I mentioned on the last slide, just by virtue of creating a creative work, you do have some rights to it. However, in order to fully kind of lock in those rights, you need to register for protection from the U.S. Copyright Office. That is going to give you the ability to file for copyright infringement in case someone does infringe upon your copyright, to file for that in federal court, which is typically going to be the best way to protect your copyrighted material. In order for something that you've created to be eligible for copyright protection, it has to be original and it has to be fixed to a tangible medium, right? So original obviously means that you're the first person to create it, but fixed to a tangible medium means that it exists out in the world, right? So it's on a piece of paper, it's on a shirt, it's in the cloud, whatever it may be. It's not just in your mind swimming around, but it's somewhere where someone else can actually verify that whatever it is that you created actually exists. So next we have patents. Now, patents protect new ideas and inventions. So they protect functional creations, right? Things that someone might create that have a functional use. And so that, is going to be like what we typically think of in terms of inventions, right? But it doesn't only include traditional inventions, right? It can also include things such as instructions, right? So the instructions on how to play a game, or it can also include designs and software sometimes, right? So in terms of protecting your ideas and inventions with patent protection, it's really important that I point out two things. Number one is that you aren't entitled to protection over your idea or invention just because you created it, right? So with trademarks, once you start using a trademark out in the world, out in commerce, if no one else is using it, then you've got you've got some rights to that trademark. Same with copyright. The second you create something that's eligible for copyright protection, you have some rights to it. Someone can't just come and take it and use it. Patents are different, right? Patents, they follow what's called first to file rules, which means that in order to get protection for your new idea or invention, you have to be the first person to file for patent protection over it, right? So if you have a new idea or invention, you want to run, not walk, to a professional who can help you figure out, one, is it eligible for copyright protection? And two, if it is, let's get an application filed to get this protected, right? And the reason too that I say you want to make sure that you get a professional, with trademarks, copyrights, those are processes that are set up to be a little bit more friendly to, someone who is not an expert or not a professional, right? And so people will file their trademark or file their copyright if they've got more time than money. And, that's they want to invest that time into, navigating that process versus investing their money to navigate that process. Patents are one of those things where patent applications can be very complex, but the main complexity comes into play with, you want to protect enough space around that idea or invention, right? So one of the requirements for patent protection is that the idea or invention has to be non-obvious, which means that there's a significant enough inventive leap, right? There's enough inventiveness between what you've created and what already exists, that it should be protected with a patent, right? There's enough inventiveness there, right? So when you're creating a patent application, you want to protect enough space so that someone can't just come in and look at your patent application and say, oh, I can create something that's like a little tweak to this, and then come in and slide in and get patent protection over it. And now, you've got a competitor in the marketplace, whereas a patent is really meant to really help you corner the market on your new idea or invention, right? And so patents is very important. If you think that something is eligible for patent protection, try to figure out if it is as quickly as possible, and work with a professional in order to help you get that patent protected. And then patents can last for up to 20 years. Some of them are shorter. It depends on the type of patent. But again, as I mentioned before, when it comes to patents, either your first or your last, right? So if you don't get that idea or invention patented or patent pending, someone can come in, they can take it from you, and they can go and get it patented, and then you will just be out of luck, right? You'll be excluded from using your own idea or invention. And so you don't want that. Last but not least, we have trade secrets. And trade secrets protect valuable pieces of confidential information that give a business a competitive advantage over another business that doesn't have that information in the form in which it exists, right? So that could be secret recipes, that could be standard operating procedures, it could be a customer list, any type of proprietary information that a business has compiled or created, put together, and that they take steps to protect and keep confidential. That's a very important aspect of this, right? So, with a trade secret, right, unlike the first three types of intellectual property that we talked about, you're obviously not going to register a trade secret, right? It's a secret, it's confidential, and registration would let the secret out, right? So how do you protect your trade secrets? Well, you protect them with contracts, and you protect them with having the proper procedures in place, right? In terms of contracts, we're talking non-disclosure agreements and confidentiality agreements. One thing that I want to point out with those is it's important that within those, sometimes a non-disclosure agreement or confidentiality agreement might have a time limit on how long confidentiality has to be maintained, right? So it might be for 2 years after the contract ends, you've got to keep all that information confidential, right? But with your trade secrets, they're only protected for as long as your information remains confidential, as long as it remains protected. So if after 2 years that protection goes away, guess what? That information is no longer technically a trade secret because you've given this other party permission after 2 years to make it public and share it as they so choose, right? And so it's important within those contracts that you make sure that any of those terms that apply specifically to trade secrets, that they are indefinite, right? And then second, so you have your contracts. The second piece of protecting your trade secrets is your procedures, right? So making sure that information is kept confidential, storing it safely, marking it as confidential, and making sure that you use technology to keep track of access, right? In this day and age, there really isn't a whole lot of reason to be sharing documents physically, right? And so you can share documents electronically and use software to track who has access to it, to revoke access when you want to or when you need to, and also to keep track of who's actually downloaded that information, right? So that brings us to the end, and I just want to finish and kind of wrap up with a recap, right? So again, we talked about what makes intellectual property so important. It's the fact that it is an asset that we can ultimately leverage and use to create passive income in our business, right? So again, if your business doesn't own real estate, your intellectual property is probably the most valuable asset that your business owns, right? And so the intellectual property rights that you have will give you a competitive advantage over others who don't have that intellectual property, and also give you the ability to license that intellectual property. And both of those rights come from the overall fact that owning intellectual property gives you the right to exclude others from using it, right? So because you can exclude others, you're also able to give them permission, which means, on one hand, exclusion gives you competitive advantage, but on the other hand, the ability to license gives you a potential additional revenue stream. And then last but not least, there are 4 types of intellectual property. You have trademarks, which cover your brand assets, right? You have copyright, which covers your creative works that are going to be distributed publicly. You have patents, which protect new ideas and inventions, and trade secrets, which protects confidential information with some type of economic value that you take affirmative steps to keep confidential. So that brings us to the end. Hopefully you found this video helpful. And, I have my contact information up here. So again, as I said at the beginning, if I can ever be of assistance, if I can be helpful, please don't hesitate to reach out. I'm here to be a resource, and, wish you all best of luck in all of your future business endeavors. Take care.